to introduce Vanessa Just. She's our operations manager for DCASA, and she'll be asking all the questions that sort of come across. I've also got Zanel Carstens, who is our Gauteng representative and also owner of Control Debt Delete Debt Counseling, who will also be helping me on this seminar. So just a little bit about me. My name is Reinhard Pettenberger. I'm the current president of DCASA and owner of Debt Therapy Pty Limited. I have been in this industry since the inception, and prior to that, I was working in the UK in the banking sector. So I pretty much have my feet in both areas. So I understand both the banking operations as well as those in the debt counselling side. So let's get on with it. So what is debt review all about, and the importance of finding a good debt counsellor? All right. So during this presentation, I'll attempt to cover the basic aspects of the debt review process and what you should look for when deciding on who to choose as your debt counsellor. So how can debt counselling help me, and do I need it? Firstly, it is important to realize that debt counselling is not always the answer to resolving your financial issues and has its limitations. And any good debt counsellor will tell you if this is the case or not, and if the process will work. Secondly, if you're struggling to make ends meet on a month-to-month basis and have received collection letters from your creditors, the chances are that you are over-indebted and should seek advice. And thirdly, if you're starting to use your credit cards to pay your debt on a month-to-month basis, this is a sure sign that you need help and should look for a solution as soon as possible by contacting somebody like a debt counsellor. All right. So who or where can I get advice from? All right. The easiest way would be to approach a debt counsellor to complete an assessment on your behalf, as most debt counselling firms will do this for you free of charge. Right. In order for a debt counsellor to complete your assessment, they'll require the following from you: consent to pull your credit report, supply them with proof of ID, and also let them know what your marital status is. Because if you are married in community of property, it would have to be a joint application. Right, so first of all, you need to complete your monthly expenditure report with your debt counsellor, and it is vital that you give them the accurate information to allow your debt counsellor to make a proper assessment of your circumstances. That way, he'll know exactly what you have left available to pay your creditors. Right? Please bear in mind that it is very important to look at your budget, especially your monthly expenses, accurately, as credit providers will look at this and question anything that they seem to think is unreasonable. Right, your repayment plan estimate. Right, your debt counsellor will make use of the systems built and approved by the National Credit Regulator and the credit providers to establish your estimated payment and repayment term based on the information that you have given them. Right. This would either be a DCRS, which is a debt counselling rule system proposal, or a pro rata repayment plan. Right. I'll discuss these repayment plans in more details later on in this presentation. Right. It's very important to note. Right. Your repayment terms from one debt counsellor to another debt counsellor should not differ significantly, as we all use the same systems, emphasizing the importance of finding a good debt counsellor or good debt counselling firm. Right. So now, if you're happy with your assessment and confident that you can cope with the agreed monthly installment and terms, then only then sign the Form 16 putting yourself under debt review. Do not sign anything until you know exactly what you're committing yourself to. I cannot reiterate the importance of this. Right, now you are legally protected from your creditors for the next 60 days whilst your debt counsellor starts with the negotiation process. Please note, this excludes any accounts where legal action has already commenced, again highlighting the need to seek advice before it's too late. Right, and it's important to note that according to the NCR, that you're now officially under debt review, and the only way you can come out of the debt review process would be under the following circumstances. Your debt counsellor completes the assessment of you and determines that you're not over-indebted. A court determines that you're not over-indebted, or you pay all your debt off with the exclusion of your bond. It is also important to note that you will not have any access to credit until your debt has been cleared or if you had your debt review flag removed, regardless what anybody tells you what you see advertised. All right, so for now, I'd just like to have some questions. So if anyone's got any questions for me, please speak now before we go to the next part of the presentation. Vanessa, are there any questions that you've seen?
No questions thus far. I have unmuted them, but it seems that they can't. So it seems that you have to mute them or unmute them from the beginning of the meeting. But do you put your questions in the message box? We'll just give you a few seconds. We'll read it out loud. Hi, Ansel. I see you have a question. Do you just want to put it on the message box for us, and then we will respond accordingly?
Right. Ansel, you've asked why only bonds. And this is unfortunately this is a ruling that has been taken place in the High Court. We originally didn't want only bonds. We wanted bonds and cars to be included, but unfortunately, according to the rulings and via the High Courts, etc., they've said it's only bonds that would be allowed. Unfortunately, there's not much we can do about that unless we actually change the laws. Any other questions? Okay, nothing else. So if everyone's happy, I'll move to the next section.
Yes. If there's more questions, I'll just refer. We can just check in the message box. Thank you.
Okay. So the next part I want to go just the job of the debt counselor, and once you have signed the Form 16. All right. All right, so now you've signed the Form 16, you've agreed to a fixed payment date and fixed installment amount, so we're all ready to go. So now your debt counsellor must send out a Form 17-1 to all your creditors, stating that you've applied for debt review and request up-to-date balances on all your accounts. Right, now creditors must respond to this request within 5 business days. If the creditor fails to do this, we as debt counsellors are allowed to use the balances that we've discovered on your credit bureaus or the information that you've given us. Right now, the debt counsellor needs to complete your assessment and determine whether you are either over indebted or not. Okay. So, and we basically have a time period of 30 days in order to do this. Right, so this is now, first of all, we send out Form 17B or 17.2C. B being a rejection, confirming that you are not over indebted. Right, should the council find that you're not over indebted, they will then inform the creditors and update the debt help system accordingly and remove the debt review status. At this stage, the NCR are the only ones that can do this. But basically, what will happen, your debt review flag will be removed and you'll be able to take out credit again. All right. Should you be found to be over indebted, the debt counsel will inform the creditors and update the debt help system, basically stating that you are over indebted. All right. And at the same time, we'll send proposals to all your creditors and await their responses. From signing the Form 16, all this needs to be done within the space of 30 days, as I mentioned earlier. All right, so now the creditor's responsibility. Right, once your creditors receive confirmation of you being over indebted, together with the repayment proposals and the cancellation of your debit orders, the following should happen. And this is as per the task team agreements. Right, cancel all debit orders. Respond to proposals sent, either accept, reject, or counter the proposals received. Send information requested by the debt counselor in the event that they suspect reckless lending. Right, and it's important to note that creditors will scrutinize your budget and question anything that they feel is out of place. So this highlights the importance, once again, of making sure that you complete your budget correctly from day one. Right, so the types of proposals that are sent by your debt counselor. Right, we have the DCRS proposal, which is also known as the counseling rule system, or the pro rata proposal. The debt counseling or the DCRS proposal may cost more on a monthly basis, but it has serious advantages for the following reasons. Guaranteed acceptance with all credit providers that have signed the task team agreement. All major banks and most credit providers and retailers have. However, there are a few exceptions, but they are minimal. Right? Here, the lowest interest rates are afforded to clear your debt in the fastest way, and this is basically the fastest and most economical way for you to actually get yourself out of debt. Right. Now, in the event that you cannot afford to make use of the DCRS proposal, there's the option of using a pro rata proposal. However, these proposals are not an automatic guarantee of acceptance and may be countered by your credit providers, as they themselves need to ensure that the debt is cleared within a reasonable period. Your debt counsellor should have explained this to you prior to you signing your Form 16. Right. Creditors will still allow a reduced interest rate and remove monthly service fees. However, as they extend the repayment term, they will increase the interest rate slightly in order as a trade-off against the extended term. Right, and they may also ask for an increase on your repayment offered by the debt counsellor, and the debt counsellor should inform you immediately if this is the case.
Reynard, can you hear me now?
Yes, I can, Simon.
So my name is Ansel.
Sorry, Ansel, yes.
Yes, so I'm going to jump back a few steps ago. So going back to the debt review, the commitment, the legalities of that, and you said that if I personally want to go under debt review, I apply for that, and an accountant person will, or sorry, a person that is signed up as a debt counselor that has their debt counseling certificate, for example, I may have 5 days before me as are you speaking about me as an individual, or are you speaking about the creditor as such? I just want to understand that.
All right, it's the creditor that needs to respond within the 5 days. But if you just give me a sec, we've got a slide or two to go, and then there's another opening box for questions and answers. So if you don't mind, and I'll answer all those questions then, if that's good for you. Okay. All right. So now, if you're able to increase your repayment in line with the request from the banks, a new proposal will be sent to your credit providers, and we'll just await their acceptance. Right now, however, should you be unable unable to make that payment, and we cannot compromise any further with the banks, the matter can still be taken to court. However, we have to take this back at the original interest rate. And the reason for this is that the magistrate does not have the jurisdiction to change interest rates. Right, now, it's something that's very important to note, right, that should your monthly interest due exceed the repayment offer made, the magistrate is obliged to reject the application, as this will technically put you in a worse off position. Right, and this is another prime example why you should really look to choose your debt counsellor wisely, as they would have been able to tell you this prior to you signing the Form 16, or at the absolute minimum explain all the risks involved. Okay, once the negotiations have taken place and agreed, all right, you'll get a court order. We need to get a court order in place, and this is either done via the National Consumer Tribunal or via the Magistrates Court. If all acceptances have been received, the matter may proceed via the NCT or the Magistrates Court. If all acceptances are not in place, the matter must be referred to the Magistrates Court. Personally, I prefer the Magistrates Court, as I find there's more flexibility. Right, and should the matter proceed via the Magistrates Court, you will receive confirmatory affidavits from your debt counsel, which you'll need to sign and return to them as soon as possible. All right, so if we can open for questions and answers again. So Ansel, please feel free to.
Okay, so this for me is really exciting. So my name is Ansel. I should have introduced myself before. So I work for the Consumer Profile Bureau, CPB. So this information obviously is very important in the sense of consumers, etc. So Reynard, I personally believe that I think this presentation would be so much greater if we had had our access to our mics, because now I have to go through all my notes. I've got so many questions for you. But Vanessa and I are at the moment in conversation with setting up a meeting with you. Apparently your Wi-Fi wasn't so good at home, so now that's going to be great. So if I could just say that I want to set up a meeting with you and with Vanessa to discuss something with regards to CPB, but this is not the correct forum for it. But I'm gonna keep my questions for you, so I'm gonna set up a meeting with you. So if that's okay with you.
No problem. Does anybody else have any questions before we move on to the next section?
Reinhard, I see we've got a question here from Zanal. We're going to read it for you. So she's asked, what happens if there's creditors that have not signed this agreement and don't accept the DCRS proposal? Will the proposal still remain as DCRS or not?
Right, this is a very, very good question. Unfortunately, basically what happens if you have a DCRS proposal, what I suggest is that you send the proposal out and you wait for acceptances. And those that haven't accepted, as soon as you have the acceptances back from your banks, lock that in, and then you might have to represent, and you have to make a different arrangement with the other providers. As in those that have not accepted the DCRS proposal, you'd need to increase the interest rates as in line with what they need. So, but my suggestion is to lock this in on the acceptances and then just move forward to the next section. I mean, this is the way it's done in my offices, but be careful, because in some instances, if you redo the proposal on a pro rata, you'll find that the banks will then change and request that a higher interest rate is paid. So, but I find in most instances, if you can just lock these payments in, then there isn't an issue. I hope that answers it for you.
Thank you, Reinhard. No more questions from the side.
Okay, so let's go into the next part, the court process through to clearance. All right. Number one, a court date will be set down and an order will either be granted or rejected by the magistrate. The main reason for a magistrate to refuse an order is when the repayment plans are unreasonable or there are glaring inconsistencies in the application. Right? Once the court order is granted, continue to make your payments as agreed until your debt is settled. And once your debt is settled, your debt counsellor will then issue you with a clearance certificate allowing you to re-enter the credit market. It's as simple as that. So let's discuss the clearance process. Right, your debt counsel will receive paid up letters from all your credit providers with the exclusion of your bond, should you have one. If you have a bond, you will need to confirm that the account is up to date from the bondholder. Right, we then update the debt help system and then send a certified copy of your clearance certificates with all your paid up letters to your credit bureaus, including the updated debt help system status, and your debt review flag will be removed. Now, please bear in mind this can take anything up to 3 weeks, although it should take 7 days, but it generally takes about 3 weeks. Right, any questions on that whilst we're at it? I think I saw a question coming from Zanel.
Yes, the question from Zanal here is there any fees the consumer has to pay the DC to obtain a clearance certificate?
No. As long as you have continued to pay your current debt counsellor on a month-to-month basis, there should be no fees to pay once your clearance, because this is all covered in your aftercare fees, which you pay on a month-to-month basis. However, stating that if you have moved to another debt counsellor and you are looking to sort of get a clearance certificate for whatever reason, you don't have you've moved to different debt counsellors and you're moving to another debt counsellors, they may charge you the equivalent of the monthly service fee, so up to a maximum of 450 Rand. I hope that clears things.
Yes, so Reinhard, perhaps you can explain to the consumers, many of them fail to find the all debt counsellors. So what happens? Can they then go to another debt counsellor to be transferred? Or yes, what is the process?
Okay, well, the process number one is obviously to try to find the original debt counsellor, but I mean, yes, as we know, many debt counsellors have left the industry. So if that is the case, you can approach any debt counsellor and ask to have your sort of information sort of transferred to them. Now, in the event that you owe your previous debt counselor a fair amount of money, they will not transfer your account until you have paid those fees off. So it's important just to bear that in mind. But once the transfer has taken place, the debt counselor will then need to get updated paid up letters, which they'll either request you to send them to them, or they can actually request them themselves once the transfer has taken place. And as they're now doing some work for you and you haven't paid any aftercare fees, they are then entitled to actually charge you that aftercare fee, depending how long it takes them to actually clear you from debt review.
Correct, Reinhard. And just to be clear, no court order needs to be obtained for a clearance or a rescission.
Well, for a rescission, yes, you need to get a court order. But however, for a clearance, as long as you've paid up all your debt, then there's absolutely no reason for you to have a court order to remove that, because your debt has been paid up in full, and that's all covered under the actual act.
Correct. Any other questions? I see there's a hand up from Mungani.
Yes, hi guys, it's Bongani from Zenowetu. I wanted to ask a question about when you're updating the credit bureaus and the DHS. Which one do you start with first? Do you start with changing the status on the DHS first, and after it's changed, that's when you update the credit bureaus, or what's the best way?
Okay. Well, first of all, you need to update the status on the DHS. Okay. Right, and then you sort of inform all your credit bureaus, because the credit bureaus will insist on a copy of the updated DHS status prior to them doing anything.
Thank you.
Pleasure.
Very nice. So I have a question. Sorry.
Yep.
I know we're going to speak, but did DCASA have a set fee, a sort of a scale on how much they can charge? So if I go to my neighbor tomorrow who is a debt counselor, am I supposed to know as to how much is going to charge me to actually help me with the whole process, or can any debt counselor charge any price?
No, all our fees are regulated by the National Credit Regulator. So I mean, there are various fees, but let me just cover the main fees that we sort of look at. I mean, basically, your first payment that you make to your debt counselor would be considered as the main fee that you pay, but there are limitations on how much it is. And so for example, let's say you're going to pay me 4,000 Rand a month, and that is the maximum I can now charge you, right, as the setup fee, which is the 4,000 Rand. Right, yeah. And then every single month I can charge you 5%. However, there is a cap on these things. So if it's a single application, the maximum I can charge you is 8,000 Rand. So for example, if you're paying 20,000 Rand per month towards your debt, the fee itself is capped at 8,000 Rand. But I don't want you to get confused where, let's say you're paying 4,000, I should be able to charge you 8,000, because that is incorrect. I mean, it's basically based on your first installment, but it's capped on those levels. Now, for example, if you're at a joint application, it goes up to 9,000 Rand. But all these fees are very much, if you can go into the NCR website, and it will cover you, it'll show you all those fees that are covered. And obviously, when you sign your Form 16, you should have all that information to hand, the exact breakdown of what all the fees are. So it's once again, it's so important that you choose the right debt counselor to make sure that you have all that information to hand before signing anything.
Brilliant, thank you.
Sure.
Apologies, Reinhard. Another question came through here. Zanal asked, do I have to use my debt counselor's attorney for my debt review order, or can I use my own attorney?
All right. Well, I mean, I suppose there's nothing stopping you from using your own attorney, but I wouldn't see why anyone would do that. I mean, because number one, I mean, all attorneys sort of get themselves into a particular profession, and they decide this is what they want to do. So the debt counselor will actually find attorneys that are actually specialized in the debt counseling process. And they've already established agreed payment amounts with those lawyers in order to give you the best possible deal. So I certainly wouldn't suggest anyone to use their own lawyer. I'd rather use the lawyer that is suggested by their debt counsellor. I hope that helps.
Yes, because it's already paid for. Am I correct?
Yeah, it's well, basically what happens is when you sign your Form 16, you are informed the costs behind how much it's going to cost you for the legal process, etc. Now, as a debt counsellor, we are the applicant, right, and not the individual. So basically, the debt counsellor is the one that actually gets the lawyer on board, and he's the one who has to sign all the paperwork in order to get the debt review process, or get the debt review order in place. Right, so but that is all covered. So generally what will happen in your first 2 months, you first of all, you pay your fees, and then the second month is where you actually pay your legal fees. And in the third month is when your creditors will then receive payment. It's pretty much the process across the board. Does that help at all, Ansel?
Yes.
Absolutely.
Thank you, Reinhard. I see Nadia puts in here the fees for the restructuring. Thank you, Nadia. And then Zanal also asked us, is legal fees kept like DC fees or not?
Unfortunately, legal fees are not kept in any way because we have no jurisdiction over these things. I mean, obviously, this belongs to the judicial side. I mean, they've got their own sort of rules and regulations. But generally speaking, I mean, you should speak to your debt counsellor and ask them what the fees are going to be. So and now, for example, when we at debt therapy, we sort of look at what the client can afford, and we have arrangements in place with various lawyers that will accept lower payments where clients do not have the funds to pay the full fees. So now our fees can range anything from 4,000 Rand up to 8,000 Rand these days. So, but if we do have a client who really cannot afford it, we even go as low as 2,000 Rand. But that's the arrangement that the debt counsellor makes with the lawyer in hand. So, and it all depends on how many applications you put through to that lawyer is where you can get these better deals sort of arranged.
So it's a benefit for debt counsellor or to use the attorneys of the debt counsellor because there's a relationship, a professional relationship between the attorney and the debt counsellors, which assist in a reduced fee or a more affordable legal fee. Correct,
Exactly.
Reinhard? Okay.
That's exactly what we do, yes.
Hi,
Bongani.
Hi, it's mine again. I have an experience with this debt counselor called Ashira Lamara. Most of her clients or his clients, I find them. Now I have, I think, 4 or 5 cases that I have from this woman. Those guys, some they have 2 debts. They are not over indebted. You can see some they don't have debts at all when you check on the credit bureau, but then on the DHS status, they are on A from 2016 and all that. So in that situation, because I had that, what you need to have like paid up letters for all the debts the client have. So in that situation, if the client didn't get joy from that counselor, and what he or she wants to do is to go out of debt review, what do you do? And the client hasn't paid off the debt.
Okay. Now the debt counsellor that you have mentioned, I mean, has been found guilty of mismanaging their practice. So what I suggest, quite strongly suggest, that you take this up directly with the NCR, stating exactly what the situation is. Now, this person has been found guilty and has been fined a substantial amount of money, which they're currently appealing. But that was about 4 years ago. I think it was back in 2017, if I'm not mistaken. So I'd certainly take that up directly with the NCR and just state each individual case and what the situation is, and hopefully the NCR will be able to help you on that.
Thank you.
Pleasure. Good. Any other questions?
Seems fine from my side.
So we can move on.
Absolutely.
All right. So let's. How do we find the right debt counsellor? Right, once again, this is so important, people. It's all about finding the right debt counselor. You've just heard from Bongani a bit earlier. He mentioned a debt counselor that hasn't been doing their practice correctly. So, and it's just a prime example of the situation people can get into if they do not make use of a decent debt counselor. Right. The first thing you need to make sure that they're registered with the NCR. All right. Then I strongly recommend that you have a look at hellopeter.com. Right. It's very simple, www.hellopeter.com. And then you simply type in the name of the debt counselor or the firm you're investigating. And as this is a public platform, it's individuals that have used these companies will tell you their experiences of the company involved itself. So you'll have a good indication whether they're good or bad, right? And next thing, check if the company responds to reviews. This will also indicate a company that actually cares. And then, are they registered with one of the associations like DCASA or NDCA? Right. Just the reason why we want people to be registered with the NDCA or DCASA is simply it's something so you can fall back on. So if that debt counselor hasn't done their job, you can go to the association and make a complaint directly against that particular debt counselor, and then the association can do the investigation as such. Right. And do they use a registered PDA? Now, PDA is a payment distribution agency, and there are currently 4 that are available. The one is -PDA, then you've got the IPDA, which stands for the Intuitive Payment Distribution Agency, DC Partner, and CollectNet. And most importantly, do not pay your debt counselor directly, whatever you do. Once again, I'm going to say, don't pay your debt counselor directly. Right, and then let's have a look at how long they've been in business for. How many staff do they have to deal with the debt review process? Now, just going through the process that I've discussed with you, you can see there's quite a lot that needs to be done. So make sure they have enough staff to actually handle your sort of case. All right. And if a debt counselor tells you you can resolve your debt for a lot less than another debt counselor, be very careful. Just remember that creditors want a reasonable proposal, otherwise they will not accept your debt review plan and they'll put you in a far worse position. Right, and the next thing I'd suggest is have a look at how they've performed at the Debt Review Awards. Now, as these are the only legitimate awards, as they are voted for by the banks and credit providers, rating the debt counseling practices themselves. Right, and you can access this via www.debtreviewawards.co.za, if I recall me. Yes, .co.za, and I would recommend anybody in the top 10 is somebody that you can sort of use. Right, and now we get to the lovely thing is, how can I get out of debt review? All right, there is light at the end of the tunnel, and there are ways in getting out of debt review. However, you need to know the facts. Right, if you're assigned a Form 16 with your debt counselor, they will flag you as being under debt review. Right, as you're now officially registered under debt review, there are a few steps you can take to have your debt review status removed. However, before we look at this, I would like to highlight a few scams that we as debt counselors see on a daily basis on media platforms and various other marketing campaigns, just to help you be aware and see what is happening out there. All right, so here are some of the scams that we see daily and things that you should know, right? The use of the NCR logo. All right, you can see especially on Facebook, I've seen quite a lot. Now, just bear in mind, only the NCR are allowed to use this logo, as it is their own and nobody else's. All right, remove your debt review flag. Various attorneys' names and companies claiming to be experts. Fix your credit score within 24 hours. Right, have your debt written off legally. New government-approved legislation or something similar to that. Get a loan even if you're under debt review. Or you receive a call from someone stating that they've been mandated by the NCR that they can reduce your payments even further, even if you have a current debt court order in place. Or a call stating that their banking details have changed and that you need to make payments to another account. Just bear in mind that payment distribution agencies do not change the banking details. And if they did, you know about this months in advance. Right, so let's just move on. So when can I not be removed from debt review? Right, you have a court order in place that states you have been declared over indebted and still have outstanding debt with the exclusion of your bond. Other than that, there is no reason why you can't be removed from the debt review on the basis that you can prove that you can now afford to pay your debt. Right, so let's have a look at the process. Right, I would suggest that you contact your debt counselor and state that you'd like to be removed from debt review as there's no court order in place and you can now pay your debt off yourself. Right, you'll need to complete a new application form with your debt counselor confirming that this is the case. Right, your debt counselor will then make use of a lawyer who will then approach the magistrate's court to declare that you're no longer over indebted. Right, your debt counsel will now update the systems accordingly and your debtor status will be removed. And the cost of this depends on the lawyer and the debt counsel you use, but it should not be more than 6,000 to 8,000 rand. All right, now should you already have a debt review order in place, right, you must first pay off all your existing debt, all right, or pay off all your existing debt with the exclusion of your bond on the basis that your bond is up to date, or have yourself declared insolvent or bankrupt in the event of your death. And unfortunately, at this stage, there's no other legal way to remove yourself from the debt review process. If somebody tells you otherwise, they're lying. Right, and something very important to remember, this is more about the actual debt review process. Like, once you've agreed to a payment amount and a payment date, it is of the utmost importance that you stick to this agreement, as creditors may terminate your debt review if you don't. However, if you do miss a payment for whatever reason, it is very important that you contact your debt counselor immediately and let them know what has happened. Only this way can they approach your creditors and see if the creditors will be kind enough to actually extend the term. And in many cases, they will, as long as you have a legitimate reason. Okay. So just some contact email addresses should you need to want to speak to any of us. So I'm Rana Pettenberger. Mine is rp@debt-therapy.net, or you can contact Vanessa which is DCASA at dcasa.co.za. Or if you'd like to speak to one of our admin people at DCASA, it's just admin@dcasa.co.za. All right, so thank you very much for listening to the this presentation. Now, if some final questions and answers, please.
Hi, Reinhard. Okay, I'm going to start with the questions in the question box. Zanel asked, is a consumer forced to use a PDA to pay their creditors monthly?
No, a consumer is welcome to sort of pay the creditors directly themselves. However, I don't recommend this for the following reasons. Number one, it just becomes far more cumbersome. The debt counselor never knows what has been paid unless the creditor sends that information directly to the DC involved, and that then needs to be updated on their payments sheets, etc., etc. So yes, it can be done, but I certainly don't recommend it.
We think that, as we said, the PDA is an integral part of the success of debt review, and it works as well, isn't that, Reinhard?
It certainly does.
And it also gives statements through every month, so you can kind of have an idea.
Yeah. I mean, you'll get a statement every single month, and so you can track your payments. And the beauty of using a payment distribution agency is that your money is secured because it gets paid into a trust account, and so there's a proper audit trail. So your money should not go missing. All right. So I'd certainly recommend a PDA over anything else.
Absolutely. The next question is, if a consumer refuses to apply for debt review order, what do you as a DC do to protect yourself if there is an issue during the process and the consumer is still over indebted and want to lodge a complaint with the NCR saying the DC did not do the work?
Right. Well, it's very important that you keep a track record of all the work that you have done. Now, I mean, I can give you some examples from my offices where we have done all the work, and we're waiting for a client to return a confirmatory affidavit, which they haven't done. All right, but there's a clear, you can clearly see all the work that has been done. There's a court set down date, We've liaised with your sort of lawyers, etc. And as long as there's a paper trail, there's absolutely no problem. But just make sure that the work has been done and that you can prove the work's been done, and you should be absolutely fine.
I have a question.
Yep.
It's probably going to sound like a very silly one. So, Renard, for example, you now have gone under a debt review. You follow the entire process. You've given your monthly installments. You've paid your fees, and suddenly you stop. Is it like double jeopardy? I mean, what happens next? Do we have to re-review the debt review, or do we have to re-review? Do we start you off as a new client, or how does that go?
So I'm not. You say you've paid all your fees and then you suddenly stop? I mean, are you talking that you're halfway through the process, or what's?
Yeah, so I'm in the process. I'm in the system now. I'm under debt review. I've been paying my monthly installments to my debt counselor, and then suddenly I stop. What happens then?
All right. Well, firstly, your debt counselor will contact you and ask you what has happened. Why have you stopped paying? Right now, obviously, there's an arrangement between yourself, the debt counselor, and the credit providers that you'll make payments on a regular monthly basis. Now, should you stop paying, your banks are then entitled to actually cancel your debt review, right? Okay. So in effect, they can just cancel the debt review process in full, and then revert to original interest rates and backdate everything. So it's one of those things where you might have the opportunity to apply again, or the other alternative that you just, as soon as you can, you just carry on paying your debt until it's paid off in full. So it is a tricky situation. But as long as you can prove to the banks, let's say, for example, that you stop paying for a period of 3 months, that's because you had a car accident or something like that, and you are unable to work. I mean, and as long as your debt counsel has been informed and he's informed the credit providers, they will generally sort of look at sort of helping you if that is the case. However, if you suddenly decide just to stop paying for whatever and not give us a reason, then the banks won't look so favorably upon that, and they might not allow you back into the debt review process.
Okay, and I have one more question, because you mentioned fees. Okay, so I'm paying my debt counselor. I've gone to them to remediate my credit. I've gone to them to say, yeah, please, I can't afford to pay this. These are all my creditors. These are all my debtors. Can you please assist me? So I've gone to them, and they've now assisted me. Okay, do they then become the ones not accountable but responsible for ensuring everything is done on a timely basis, on a monthly basis? Is it now their responsibility?
All right. Well, firstly, it's your responsibility to make your monthly installment as agreed, right? Yes. And then it's also, as a debt counselor's responsibility to carry on making sure that payments are made as per the plan.
Okay.
Right, and that becomes the debt counselor's responsibility. Right, so it's very important that the debt counselor then makes those payments on your behalf, and that's why I suggest that you use a payment distribution agency, as they are tied in, and all that money is put into a trust and it is properly audited. And hence again why I say do not pay your debt counselor directly. Always make payments through a payment distribution agency. That way, protecting yourself and the debt counselor to a certain extent.
Like an individual, like you mentioned, check that their NCR registers, check that there's no complaints with them in Hello Peter, check that what the response reviews with. So me as an individual must do my investigation as well on which debt counselor I choose.
Exactly. I mean, it's the same thing if you're going to buy yourself a car. I mean, first of all, you're going to find you're just not going to go to any dealership, are you? I mean, you're going to rather go to a dealership that you know has got a bit of a decent reputation. So it's very much the same thing.
Okay, I understand now. Thank you.
Cool.
Okay, Renard, I think you've partially answered this, but I just wanted to give this question through from Nadia. Please explain what happens when creditors terminate the agreement if payments have been skipped. Is there a pause button and we just resume thereafter?
All right, this is a tricky question, but
yes.
I mean Now, what I've found, I mean, obviously your credit provider is entitled to terminate the debt review, and we all know there are certain creditors that are quite happy with once they've terminated, they do not want to allow it back in under the debt review process. However, from my experience over the years, if the client starts making payments again to that account, no matter which department has landed up going to, they are at least showing intent that they want to pay their debt off, and no further action will be taken. Right? They might end up paying more because the interest rates would have changed. However, as long as they can see payments are going through, there's no court in the world that will suddenly turn around and say this client is not trying to pay their debt. So, and that's the basis I'd work on.
Thank you for that answer, Reinhard. Following question from Zanals: can consumers decide? Maybe I can rather rephrase. Can consumers and debt counselors just decide what debt they want to include in debt review or not?
Unfortunately not. I mean, you need to include all your debt. That's as simple as that.
And what agreements can be excluded? Let's phrase it in that sense.
Right. Well, the only agreements that can be excluded are those where legal action have already been taken, and your incidental credits, such as your doctor's bills or your monthly cell phone bill, etc. These things would be excluded.
Okay, and then I do know that usually when summons has been served on a consumer, then it's excluded. Prior to that, there's actually case law to state that you can still apply for debt review, if that makes sense, what I'm saying right now.
All right. I mean, yes, you can still apply for debt review. However, it is up to the credit provider or whoever is representing them whether to allow that account under debt review or not. I find in most cases that they do allow it, but it's just one of those things. You need to speak directly to the credit provider or the lawyer dealing with that case in particular.
Okay, Nadia's asking, is there a difference in skipping payments before or after a court order is granted?
Well, technically, there's no real difference. I mean, at the end of the day, yeah, obviously, if you miss a payment prior to the court order being granted, and the court order is granted the month after, there's very little the banks can do, apart from take the matter back to court to ask for a rescission because it wasn't in line with what was agreed. So, I mean, but the likelihood of the banks doing it is very low. So, but if a client misses a payment at any stage during the debt review process, I mean, your creditors are entitled to cancel the debt review. But saying that, in most instances, they won't do that, and because let's face it, the banks do want to get their money back, and if they are sort of one or 2 months behind, it's not the end of the world, and they'll generally sort of accept it.
Bongani, do you have a question? I see your hand is up. I'm not sure whether there's an old hand.
It's an old one, eh?
That's fine.
Cool. So, yep.
Yeah, so you've been a wealth of knowledge. I think it was an absolutely superb presentation, by the way. I'm sure I'm going to ask Vanessa to send me a copy of.
Well, that's lovely to hear. Thank you, and I'm sure Vanessa will happily send it on to you.
Yes. That's it from my side as well. No more questions.
Okay. Well, if nobody has any more questions, I'd like to wish you a fantastic rest of a Sunday. So enjoy it, have fun, and yeah, we all got work tomorrow. So
thank you, Reinhard, for the time and the opportunity.
So let's enjoy.